It is a thrill to be back in Scandinavia with all these valiant Nordic women. And the way that you have inspired me is that I will propose a new and difficult idea today that goes counter to some trends of the way people are thinking, in particular about rape. I thank the organizers for inviting me and for doing all the work necessary to bring us together. Rape is recognized in international law as a gender crime, meaning it happens to women because they are women, to some men because they are men. A crime of gender inequality. This analysis is partly put into effect in international law, including in the Rome Statute of the International Criminal Court, but it is not implemented in any country's domestic law. So my question is, what would a rape definition look like that was governed by sex equality principles? Rape is generally defined in Western countries as sexual intercourse by force or without consent, or both. It is only without consent in the UK. It is by force and violence only in France. Most US jurisdictions require both. That is, both by force and without consent. Neither or none of these has a good track record, even for reported rapes, which are, of course, a very small proportion of actual rapes. The conviction rate for reported rape in the UK is around 6%. In France, the best I can find is a breathtaking 2.6%. The conviction rate for reported rapes in the US, where most states require, as I said, some version of both force and non-consent, is between 12% and 25%. Given that in the United States, about 1 out of every 10 acts of rape or attempted rape that essentially fit the legal definition is reported, this is pretty appalling. Consent definitions, and this I'm now talking about in which the prosecution has to prove lack of consent, require that a woman be believed concerning a sexual fact that is by its nature subjective. This is why consent definitions put the victim on trial. Essentially, it attributes victimization to the victimized. And it makes a rape case be about what she was thinking or about what he thought she was thinking, rather than about what he did. It makes rape occur in her or his mind. It makes it happen in someone's head rather than on her body. It's therefore no surprise that in legal application, consent has been found when women are married, drunk, or drugged, repeatedly said no, were asleep, comatose, just seen to be raped by several other men, or consent has been deemed obvious when a woman is threatened with deportation or false criminal charges or loss of her job as a way to force sex. In legal operation, consent to sex is routinely found in situations of despairing acquiescence, frozen fright, terror, absence of realistic alternatives, socially situated vulnerability, and in some cases, even death. Prostituted sex is regarded as consensual because it is paid. What I am telling you is what the word consent actually means in law. The often accompanying standard of mistaken belief in consent means that if the accused is found to have believed she consented, even though she did not, that isn't rape either. In societies saturated with pornography, a lead pipe over your head can sincerely be believed to produce consent to sex. It is no surprise that the rough sex defense has become increasingly used and effective. In other words, consent is often found in situations where considerable force was used, building into law the misogynistic assumption that women want to be forced into sex. The same assumptions tend to be attributed to gay men when they have sex with another man and claim rape. Assumptions that feminize him on a gendered basis. If sex occurred, her consent is essentially presumed on the most minimal of acquaintance between parties, and the survivor has to disprove it. Socially speaking, if sex happened, or if a woman had ever had sex before, essentially and especially with the accused, her consent is effectively assumed, and she has to then disprove it. Consent in law is consistent with economic, psychological, and hierarchical threats, so long as physical injury or life aren't threatened, for which purpose rape itself is generally not considered to be a physical injury. Now, consent as a concept was never designed to apply between two people in civil society. It was given its meaning in Western liberal philosophy as the basis for legitimizing the obligation to obey the laws of the state. Even as a fiction, it never envisioned equal parties. It exists to rationalize the exercise of dominant power over subordinates. Applied to sex, he is the government, she is the governed. Its purpose is to attribute and justify the obedience of the powerless to the rule of the powerful. You're regarded as consenting, for example, whenever you don't leave. You consent because you are there. Is this sounding familiar? Whether leaving is a realistic option or not. Silence in sex, as in governing, is deemed consent, not dissent. These assumptions, along with the presumption that the two parties are somehow equals, which is never either articulated or justified, operate powerfully in sex unequal circumstances, contrary to realities. Now, legal attempts to correct for this social burden of proof, this assumption of yes, this women being walking consent, by adding additional words to make consent mean anything at all, such as positive, chosen, affirmative, autonomous, informed, conscious, freely given. You have to add all this on to the front of consent to make it mean anything, cannot be relied upon to overcome its basic meaning. Fundamentally, it needs to be faced that consent is not an equal concept. It is an intrinsically unequal one that presupposes an actor and an acted upon. The purported form of power of the acted upon being acceding to the actor's actions, in other words, doing what you are told to do. It tends to presume the parties are equal, as I said, whether they are or not, and relies on an illusory image of women's agency under conditions of inequality, as if we can be free without being equal. The corresponding fantasy, well intended by strong progressive women who often accept this term politically and argue for it, thinking that if consent is the legal standard, what a woman says, even what she actually felt she wanted, whether she says it or not, will be believed and will carry the day. They believe it will determine in a criminal trial whether sex was rape. This doesn't take into account that the whole concept of consent relies for its social appeal on the assumption that it stands in for desire, that is what she actually wanted. But there's nothing in law that limits it to that. In actual social discourse, sex that is actually desired or wanted or welcomed is never termed consensual, because it doesn't need to be. It has mutuality written all over it. Sex you actually want. You say, I had a great hot time last night. You don't then follow up by saying, I consented. Although the European Court of Human Rights and the CEDAW Committee have both been telling us that consent is the core of an equality approach, for these reasons of theoretical principle and legal practicality, it isn't. What it is unintentionally endorsing an active-passive model of sex and the social conditioning to trauma and acquiescence that goes with it. And it is a pathetic standard of equal sex for a free people. Now, force definitions have also been problematic, and their biggest problem is they've been confined to physical force, and then they require resistance. So, on the view that rape is about what usually a man actually did, I think a useful legal starting point is the Akiyesu decision from the Rwanda Tribunal. Rape is defined as physical invasion of a sexual nature committed on a person under circumstances which are coercive. The notable features here are absence of non-consent as essentially redundant. In other words, coercion is present because real desire is absent, and the exclusive use of coercion, which can be circumstantial as well as physical. Now the problem is to adapt it to domestic circumstances. And for this, I propose adapting the Palermo Protocol. This draws on the insight of survivors of prostitution who often cogently describe prostitution as serial rape. With this in mind, consider the international definition of sex trafficking, the destination of which is prostitution. It prohibits the use or threat of use of force or other forms of coercion, abduction, fraud, deception, or abuse of power or a position of vulnerability for purposes of sexual exploitation. And then it says, where any of that is done, consent of the victim shall be irrelevant. So I'm proposing rape redefined. Take the best of the international definitions, the insights of prostituted women who, by the way, know everything, and redefine rape domestically as a physical invasion of a sexual nature under circumstances of threat or use of force, fraud, coercion, abduction, or the abuse of power, trust, or a position of dependency or vulnerability. Then recognize that psychological, economic, and other hierarchical forms of force are coercive, including age, mental and physical disability, and all other inequalities, including sex and gender. Add in, a vulnerability includes drunkenness, unconsciousness. Inequalities would be recognized as a form of coercion when mobilized to force sex in specific interactions. In other words, for a criminal conviction, we need to show the active exploitation of the inequality, not merely the fact of it. And then where any of the listed means are used, the consent of the victim would be irrelevant. Apparently, it is difficult to think about sexuality in equal terms. The Swedish model of prostitution, become now the Nordic model, showing world leadership, is educating the world that paid sex is forced sex, setting a standard for what men's violence against women looks like. This definition of sexual assault in terms of conditions of coercion could do the same. Let's think about it together. It all starts somewhere. Thank you, and thank you to the interpreter for allowing me to communicate.